Yeah, we're back for part 3. We're going to continue to expose the Breuder contract for what it really represents to the citizens of this state. I'm Kirk Allen with Edgar County Watchdogs. This is John Kraft.
Yep.
Shall we dive right in?
Yeah, now we're going to talk about the board's retention of Rathje and Woodward. He says the impropriety of their retention of them is demonstrated in the fact that they filed a lawsuit against the board in DuPage County, and that lawsuit was filed on behalf of Fort of Illinois, Edgar County Watchdogs, Adam Angiaski, Kirk Allen, John Kraft, and the subject matter related to the lawfulness of the board's approval of Breuder's January 2015 contract. What it really was, it did relate to that, but the main part was they kept holding meetings in rooms that were too small. They promised to move if they had enough advance notice. They declined to move, 2 meetings in a row.
Yep.
So they was so this started before we knew they were going to give him a contract in January. It started in November. We requested, in December we requested again, and we wasn't going to let it happen in January. So we sued, won. They had to move to a larger room, and more than 500 people showed up that day.
And at that meeting, they redid everything we said that they did wrong at the last meeting.
Correct. And he says he's insinuating there's a conflict of interest, but we signed disclosure papers giving the law firm.
Yeah, we signed a release.
Approval to release everything.
Right.
Everything that we gave them to talked about. So there's no secrecy there. We gave them approval to release everything. We waived our attorney-client privilege. Then they talk about Schuyler, how do you pronounce that?
Schuyler, Roche, and Krisham.
Yeah. Claiming that Dan Kinsella had a relationship, a working relationship with Hamilton prior to that, because he went to the board meeting with her.
He claims that he's represented her, but he said in public meeting that he hasn't represented her. He's talked on her behalf, but he hasn't represented her in any legal action.
Yeah. He can do 75, I guess.
Next one, they claim Hamilton admitted that the retention of Rathje and Woodward and Schuyler, Roche, and Krisham was meant solely to ensure the board would fulfill the political agendas of defendants Hamilton, Mazzocchi, Napolitano, and Bernstein. How in the world could they even remotely think they could prove that?
Well, they say that on Chicago Tonight show, she said the most important thing is not necessarily optics, but solving the problem. Hiring the right people to solve the problem. Well, that's what you're supposed to do.
Right, that's what you got elected to do.
If you hire the wrong people, like Dr. Breuder, he creates
All right, on to the next one. Since April 30th of 15, through Mr. Kinsella, or the board through Mr. Kinsella, has conducted the internal investigation authorized by the resolution akin to a witch hunt. Now, how is exercising a resolution a witch hunt? He was told to investigate. That's what he did. They claim that he ransacked the office of Breuder's longtime secretary in search of information that defendant Hamilton, Mazzocchi, Napolitano, and Bernstein could use to support their wrongful efforts to terminate Dr. Breuder. Kinsella and his team have conducted similar searches of Dr. Breuder's former office and the office of several other administrative staff. Isn't that what an investigation does? You go through every drawer to identify anything that's going to support the wrongdoing.
And I doubt that they ransacked.
Right. Well, that's one of those emotional terminologies that they want to throw in there.
In 77, the internal investigation authorized had uncovered no evidence or information supporting Breuder's terminating. Really?
Now there's another one. This is one of those you got to really look at the language in it. It says by August 2015.
Oh yeah, there you go.
So what happened after August 2015? Well, we know he wiped his iPad. We know there's a whole litany of other wrongdoings that the HLC has found, the ICCB. I mean, there's plenty of things that have been identified, but by putting that first 3 words in there, by August 2015, part of the statement may be true.
So then it talks about the board authorizing the request, the DuPage County State's Attorney to enforce the non-binding Illinois Attorney General opinion, which stated that the board's approval of the third addenda of Breuder's contract partially, how can he partially violate? It violated the Open Meetings Act. The state attorney has prosecutorial discretion.
He has the power to enforce the law, and he chose not to.
Just because he chooses not to enforce it doesn't mean it wasn't a violation.
And I think the fact they ask him to, they're performing their duly elected duties. They're trying to get people to do their job.
Then he says on the 21st of August that Hamilton wrote to the state's attorney requesting that he issue a binding opinion. Well,
State's attorney can't issue a binding opinion.
Exactly. There's no such thing. They asked him to prosecute the violation, and he chose not to do so, and that's the bottom line.
Yeah, the next one's really interesting. He points to the state's attorney's response.
I think we did a whole article on that.
We did a whole dedicated article to it. In denying the request, state's attorney provided a detailed analysis of the AG opinion and the enforceability of actions made in violation of the act. He claims the state's attorney determined that the third addendum to Breuder's employment contract was not void due to the violation stated in the AG opinion. Well, that's not exactly what he said.
No, and not to mention that he doesn't have the power to determine anything, only a court does.
Right. And he specifically says in that letter, actions taken during an open meeting are voidable. Leaving that out is a slick way to bank on the judges not reading the actual state's attorney's letter. Because he said that although the OMA was violated, that action didn't void, but it is still voidable.
Yeah. So then it talks about a resolution to declare Breuder's employment contract and all related agreements void ab initio, and then he says it wasn't supported up by any contract provision, statute, or other legal authority. Well, yes, it was. It was supported by case law.
Supreme Court case law.
Supreme Court. In a case that had Edgar County's name on it.
Which is just so ironic.
Oh, yeah, it is.
Let's see. Hamilton maliciously commented to the public that Breuder's employment agreement was an outrage and blatant attempts to defy the voters. I think most would agree with that.
That's free speech.
Yep. Made several comments signifying Breuder had maliciously and unlawfully forced prior boards into executing his employment agreement. I don't recall that she ever said that in any public meeting.
No. And in actuality, prior boards never executed or took any action basically on his employment agreement, which is why they violated the Open Meetings Act.
Again, the next one, they claim the same thing with Mazzocchi, claiming she made basic comments prior to the vote. All of these are things happen in a public meeting, sharing their perspective of the situation. And the insinuation is that anything you say at a meeting can be used against you in a court of law. Well, that's not how it works. You have, your speech is protected during public meetings.
And then he claims that they prohibited him from visiting the campus and consequently from attending any and all board meetings. Wrong.
There was no court order stopping him from coming to that
It's
campus.
a public meeting, he can go. The college can restrict us from campus unless it's a board meeting, and then they have to do a restraining order with the judge.
Right.
Then they talks about the sham termination proceedings. And, you know, they were performing their elected duty.
But calling it a sham, you know,
Yeah, that's means it is. It's obvious, and we're gonna have to stop here in a minute. It's obvious that this was designed more for media to write about.
Oh, it's unbelievably, it's sensationalism at its finest.
Yeah.
And even reading through the exhibits, they pick and choose key points, and unfortunately, a lot of times you have judges that don't read every single line of an exhibit. They read the brief and they assume that everything in the brief is accurate, and although it may be accurate to a point, it doesn't include a lot of the fine details that disproves the very statements that they're making.
Yeah, and then he talked about the January 15 recording, and that McGuire warned those trustees, and that her comments were supported by the recording of the closed session board that was leaked. Of course, he probably has no idea how that got leaked.
No, no idea at all.
And then the last one. On September 17, defendants voted on and approved by majority of the vote the appointment of Joseph Morris to preside over the termination proceedings of the hearing officer. So, and then due to a controversy, the board voted on and approved the appointment of the new hearing officer. So they were listening to what opponents had to say and trying to take action to ensure a fair and impartial hearing.
Yeah, and the appointment of Morris, they improperly claimed that they have had to appoint someone else because of a controversy. Controversy had nothing to do with it. It was a matter of time constraints on behalf of Mr. Morris, as we understand it. But that's not what they wanted to report in the press. So there's about another 40 or 50 points to go through. We'll have to catch up on another time. We have a little more time to go through in detail. But for now, I'm Kirk Allen.
John Kraft.
We'll see you soon.